Hello there, woven web enthusiasts. Today we have a story out of the Superior Court of Pennsylvania regarding a paternity suit in Martin v. Martin from 1998. And below I have some dates along with a list of the parties involved. The appellant, Pauline A. Martin, appeals from the order of the Court of Common Pleas of Tioga County. This court affirms. On October 22, 1995, Pauline Martin gave birth to a daughter, Tiffany Martin. At the time, Pauline was divorced from her former husband, Leon Fuller, and was married to appellee David Martin, to whom she had been married prior to her marriage to Fuller. Although Pauline and David Martin were married when Tiffany was born, they did not reside together at that time. The parties lived together for a brief time during their second marriage. On August 27, 1996, David Martin moved out of the parties' residence. As a note, that's less than a year after Tiffany was born. Pauline Martin filed a complaint in support, and a hearing was held in October of 1996. At the hearing, David Martin acknowledged paternity of the party's older child, David T. Martin, Jr., who was born on May 24, 1993, during the party's first marriage. At the conclusion of the hearing, the court entered a zero-support order with respect to both children. Then, on April 22, 1997, David Martin petitioned the court for blood tests to determine the paternity of Tiffany Martin. In her answer, Pauline Martin responded that at the time of Tiffany's birth, David Martin did not object to placing his name as the natural father on Tiffany's birth certificate. She also contended that David Martin, Pauline, Tiffany, and the party's older son had lived together as a family, and that David Martin had acknowledged Tiffany as his daughter, evidenced by a card he had sent to her that he had signed, Daddy. Pauline also argued that David Martin was barred from contesting paternity under the doctrine of res judicata because his exceptions to the support order wherein he had contested paternity had been denied. Following a hearing, the court granted David Martin's request and ordered blood tests for Pauline Martin, David Martin, Tiffany Martin, and Leon Fuller. And note that Leon Fuller is the ex-husband of Pauline Martin. This appeal followed. Pauline Martin raises one issue for our review: whether the court ignored a legal presumption and statutory law and abused its discretion when it ordered blood tests of mother, husband, and child at the request of husband when husband acknowledged the child for 1.5 years since the time of the child's birth. In the case before us, Pauline was married to Leonard Fuller at the time of Tiffany's conception. She was married to David Martin at the time of Tiffany's birth. Pauline argues that the court erred in refusing to apply the presumption of paternity against David Martin because she was married to him at the time of the child's birth. In this case, Tiffany was both conceived and born during marriage. The two critical points, however, involved two different marriages. When Pauline sought support from David Martin, the parties were separated. Realistically, there was and is no intact family. The evidence in this case indicates that Martin was present during the birth of the child and lived with the child for 18 months. By his own testimony, Martin offered little caretaking and even less financial support. During the time the family lived together, Martin was unemployed and offered no financial assistance to his wife, in whose name the apartment was rented. Essentially, Martin fulfilled no fatherly obligations. A name on a certificate does not create a father-child relationship where one in fact does not exist. This alone is insufficient to support a finding of estoppel. We conclude, therefore, that the evidence presented does not support a finding of paternity by estoppel in Martin. Furthermore, we point out that the public policy behind the presumption to preserve a marriage in the face of a dispute over parentage is realistically advanced only when a third party, one outside the marriage, asserts his paternity against the husband. On the contrary, once a man attempts to refute his paternity and is met with the presumption, we delude ourselves if we believe clinging to the fiction can preserve the marriage. The goal of this Commonwealth, of our nation, is to foster responsibility in parenthood, not maintain barriers that shield one from it. A practical and effective paternity determination will arguably advance this goal. If blood tests cannot be so easily avoided, one may more fully realize the consequences of his or her actions. In essence, only one man can be the biological father, and when his paternity is determined, he is the only man legally obligated to support the child. In this case, where no intact family will be preserved by application of the presumption, the search for the truth should not be denied. Therefore, blood tests were properly ordered. We affirm the trial court's order. Order affirmed.